I now propose the question, which is that the Employment Amendment Bill, Senate Bill number 11 of 2022, be now read a second time. Let's have the first bite from Honorable Jackson Kosgei.
Thank you, Mr. Speaker. In principle, notwithstanding some gaps in this bill, and which I believe it can be treated by various laws established while and when we shall be looking into it in details, I support the bill personally for two reasons. One, employee right to disconnect helps to protect the employees against burnout hazards. Second, I support because it protects the workers against exploitation, where some organizations have used workers and mistaken loyalty to mean a right to infringe on the right of workers. Prime Minister, the current Prime Minister of Australia, Anthony Norman Albanese, said, and allow me to quote, Mr. Speaker, what we are simply saying is someone who is not being paid 24 hours a day shouldn't be penalized if they are not online and available 24 hours a day. I am sure the reason why hours have been defined, how many hours a worker should work in a week, I understand it's about 45 hours. The right to disconnect, therefore, has been said by scholars that it is an entitlement not to be contacted by employer during out-of-work hours as per the employer's policy. There must be a policy that is guiding every employment and creating a workable environment in every organization. Mr. Speaker, this encourages the right to privacy. Some people have made telephone calls being the boss, even in midnight, calling somebody's wife or husband, causing disunity in families. We need some kind of a working relations that dignifies a worker. Simply because he's working for you doesn't negate. The second thing I wish to refer, Mr. Speaker, is that in corporate governance, there is a cliche of professional distance. This is where we exercise it. Yes, no doubt, there are areas where relationship between the employer and employees are strong, well-connected, caring relationship with the people and all that work together. That one is encouraging transformational type of leadership where staff owns the organization. Then you need to have high level of motivation and several others. Mr. Speaker, in principle, I wish to support this bill, but I want to agree with the speaker that has just spoken that there are so many areas that needs to look at the gaps. With that, Mr. Speaker, I support.
The Honorable Gitonga Murungara, do you want to speak on this? Proceed.
Yes, thank you very much, Mr. Speaker. Mr. Speaker, I have gone through the bill as presented from the House of the Senate. I've also gone through the committee report as prepared by the Labour Committee. And having looked at this bill, the cardinal principle of legality is that you cannot approbate and reprobate at the same time. There is no way you can confer rights upon persons without corresponding obligations on them too. I am not very sure where this bill has been lifted from, but it seems to be actually in contravention of employment laws in the country, and especially bearing in mind that employment law is civil law. It is not criminal law, it is civil law. It is based on contract between two persons, an employer and an employee. There are always arguments whether this contract is at arm's length, but provided that it is supported by consideration, it is a valid contract, and the courts have held so. When you confer a right on the employee to disconnect from their employer, the next question is whether the employer has a right to disconnect from the employee. It cuts both ways, because whatever makes an employer to connect with an employee outside the working hours may be the same reason why the employee must connect with the employer outside the working hours. Therefore, one reason I oppose this bill is due to the fact that it does also not give that right to the employer to disconnect. Let's move on to the element of disconnection, which is actually criminalized by this particular act. That if anyone contravenes this section, it's liable on conviction to a fine not exceeding 500,000 shillings or imprisonment for a term of 1 year or both. First and foremost, the fine and the prison term are disproportionate. You cannot be fined 500,000, and if you fail to pay, you're in prison for 1 year. It has to be commensurate. So the number of years must be slightly more than what is provided here. Number two, this is a contract between two parties, such that one party breaches the contract. Why would the other party be taken to court, convicted, fined, or sent to prison? The remedy for civil cases, for civil breach of civil rights, is actually damages. So the employee should be entitled to an action in damages if the employer breaches this particular provision. I have seen there is an exemption on essential services which are listed under the Labor Relations Act. But essential services may not necessarily be what we know in common life. There may be a reason why an employer would want to connect with the employee outside working hours, purely to ensure that an element of the contract being executed is actually performed. Correspondingly, there may be a reason why the employee would want to connect with the employer during outside hours. For example, during time of illness, where we have to get maybe a cover to hospital, an ambulance to hospital, or whatever other aid that may be necessary. Number three, we know very well in the contracts of employment, we have working hours. These are always set out in a contract of employment. If you work outside those hours of employment, you are entitled to a payment. That payment is known as overtime, because you're working above the hours prescribed for you to work. Now, what is the problem with an employer connecting with an employee to work overtime, for which there will be commensurate remuneration? I don't see any, and this is why I oppose this particular bill. In essence, this bill goes towards breaching contracts of employment both ways. It does not help modern day market in employment as required. We know employment market has evolved over a period of time. beginning with communal African societies where there was actually no employment, all work was communal, and nobody expected any remuneration. From there, of course, we went to the ugly scene of slavery, where some human beings felt that they were entitled to labor without paying for it. Exploitation. That was allowed, and we moved to another era of master-servant relationship. This is where the employees were tormented by their employers on the basis that they were servants while their employers were masters. Today, we've moved to what we believe is almost an actual situation of labor relations, contracts between parties at arm's length. And this is where we find this law coming in to actually breach that particular relationship. And finally, which court is going to deal with breach of this particular section?
What's your point of order? Because
Thank you very much, Honorable Speaker. I'm raising person to start on number 35.
wow. Proceed.
Thank you, Mr. Speaker. Mr. Speaker, I think because of the issue of the quorum, we can ask the mover to reply. Thank you, Mr. Speaker.
You have not pronounced yourself clearly on the standing order that you are actually raising. So
Thank you,
you
Mr.
are
Speaker.
combining two things there.
Thank you, Mr.
Mover
Speaker.
to reply, you are also talking about quorum. What are you talking about, Honorable Member?
Thank you very much, Honorable Speaker. I have just consulted with my senior here, and he has advised me to come back to that point of order later. Thank you, Mr. Speaker.
Very well, Honorable Member, you may proceed.
Thank you very much, Mr. Speaker. Mr. Speaker, Honorable Kururia is a young legislator. He's learning how to handle the ropes, and soon he will know the distinction between the two and when they can actually be raised. But I think this is a bill that has a lot of interest, and we may debate on it slightly more before the mover is called upon to reply. Then what I was saying is the labor relations under the Labor Relations Act are governed or are enforced by our employment courts. Our employment courts are not criminal courts, they are civil courts. So if anybody breaches this particular section, which court is going to be charged with arbitrating between the parties on their rights, and especially when it comes to criminal justice? Would an aggrieved party go to the CID, the police, the DPP to complain, after which the DPP would prefer a criminal case against the offending party? That is what we ask. Or will the aggrieved party go to the Labor Relations Court, file a civil complaint for the person to be held liable and award damages? That is another question. As I conclude, Mr. Speaker, this is a bill which, in my estimation, has not been properly thought out. It is not actually in consonance with our employment laws, and it needs to actually be rejected. So I do oppose this bill entirely.
The Honorable Elachi.
Thank you, Mr. Speaker. I also rise to reject this bill. And Mr. Speaker, when I listen to the speakers that have been there,
Yes, what's your point of order?
Thank you very much, Mr. Speaker. I rise pursuant to Standing Order 83, as read together with Standing Order number 95. Mr. Speaker, as you have just heard, everybody who stands rejects. Would I be in order, Mr. Speaker, to request you to call upon the mover to reply, so we don't waste a lot of time with rejection, because it appears has been totally rejected, including even the Honorable Elaji. She just opened her mouth and she said, I reject, before she says so. So, Mr. Speaker, I think we'll be wasting our precious time without anticipating the next order. Mr. Speaker, would I be in order to request you to call upon the mover to reply? I thank you.
We have heard you, yes, but let's allow the Honorable Lachi to finish, and then I will put the question to just weigh what the House mood is like. Proceed, Honorable Lachi.
Thank you, Mr. Speaker. Mr. Speaker, it will be good to give with reasons that, first of all, Mr. Speaker, when you go through the content of the bill and look at how we manage the laws of employment in this country and just across the world, Mr. Speaker, and the person who thought about this seems to have not looked at our Public Service Commission Act. That indeed, even when you are employing, he never even specified what cluster of employees is he talking about. Because if they are civil servants, then you can't treat them according to what he would wish. And therefore, he's either talking to a group that we have not seen working in this country or is about to come, so that you give them such regulations, knowing very well the moment you go to an interview, Mr. Speaker, and you are given now a letter of acceptance, then there are rules and regulations of that institution that you abide in as their code of conduct of work. And Mr. Speaker, I normally say there are 5 behavior models for an employee in any workplace. 1, trust. 2, you must learn how to deal with conflict, commitment, accountability, and results. Now, when he talks about time, that when you go overtime, that now the employer cannot even call you out of working hours. What about if you, as the employee, has been given an assignment, you have been so slow on your assignment, and you have to go indeed beyond the hours that you are employed? What happens to this person? Will he take advantage and use the same policy to take his employer to court? So, Mr. Speaker, when we look at such a bill and when we tell the Senate, and I want to tell the Senate, when you're talking of employment, it is the most sensitive thing. And that is why any lawyer who walks in court on a matter of an employee, the first thing the judge does is to give orders to that person. Then you now come and go through your case. So if they find you culpable, yes, you will go home. If not, but always you are given orders to return to work. And therefore that protection is there for any person who is employed in this country, Mr. Speaker. And therefore for them to come and now define, unless we are saying, and I'm not saying us, I look at the Senate and I want to tell them they have to be looking very critically at the work of our people who have been employed in the counties. They need a critical law just to get their pension. How I wish they can bring that in this house. They need a critical law to safeguard them in how you find a governor can just decide today, Mr. Speaker, you are not there, you won't be employed, you have been employed for 10 years, you are thrown out in 1 second. They need now to bring an employment law for county government workers that can protect them properly in the work they are doing and ensure even this overtime. Most of them do not get. So you find county assemblies are even more organized than the executive side. So how I wish that is what they can do for us, so that even those in the executive side can find themselves in a proper way and a proper contract. If I'm given a contract of 3 years, 4 years, 5 years, it does not become a political contract, but it becomes a contract like any other person who is employed in this country. So for them to bring us this, I think it is very unfortunate, but I want to say we are not rejecting this bill, Mr. Speaker, because it is a Senate bill. We are saying you are contravening the laws of employment in the country. They are well stipulated. We have different articles that take care of that. If you want to amend, then you have to go through all those laws and then bring an amendment that is very clear, and we shall look upon it and be able to support. Lastly, Mr. Speaker, we have to also inform the Senate that when you are talking about employment, please cluster so that we understand. Are you talking about those who are on contract? Are you talking on pensionable and permanent? Are you talking about informal? Are you talking about our Adobe services? Who are you giving this law to enjoy? Because even if you ask who are the beneficiaries of this law, the civil servants, Mr. Speaker, our teachers, everyone can never be a beneficiary of this. Because if you are a teacher and you have students who are in boarding school, you already agreed with the code of conduct that I'm in a school that is a boarding school, and you can be on duty at any given time. And therefore, you will receive calls from your principal or even from above beyond to ensure that safety is taken. So as much as we would wish, Mr. Speaker, I want to say it was unfortunate for a bill like this to come here, and also unfortunate in public, when they went for public participation, I'm wondering who they went through, because some people would have also questioned, even those stakeholders who employ, they were supposed to also say a few things on this bill so that both parties can be in an agreement of how to do it. With those few remarks, Mr. Speaker, I beg to reject.
The Honorable Bernard Kitur, you know, Standing Order number 95 also depends on the prerogative of the Speaker to make a decision on the same. I've already made a decision, and therefore, Honorable Bernard Kitur, you may proceed if you want to speak on this.
Well, Chair, Mr. Speaker, sir, I stand to reject this employment amendment bill, Senate Bill number 11 of 2022. And first of all, on the fact that in as far as it's important for employees to be respected by their employers, and that it's also important to have a time frame of work, because when you do have a contract between an employer and employee, it should be stipulated based on time. And as far as it's a progressive bill towards bringing in order on areas of employment, I do find that it doesn't fit the Kenyan model of saying that, for instance, you come in at 8 and by 5, you completely disconnect. You cannot be able to engage with your employer. I do not think we've reached to that point where we operate in a way that when it gets to that stipulated time, everything completely disconnects. So I don't feel that it is a practical bill in itself. And secondly, there are issues that had been raised that it helps to reduce exploitation by the employers, which wasn't very clear as such. I still want to also raise that this amendment only fits employers in the private sector, but not much those in public sector, like those working in government or teachers and such kind of jobs. So to me, I still feel it is not balanced. Also, the aspect of saying that this only applies for organizations that have more than 10 employees is also discriminative. What happens for those that have less? Therefore, I do not want to belabor much, but on the overview, I stand to reject this bill. It is a good one, it has come in, but I don't think we are in that space that we can be able to have such a very tough bill. Of course, I saw also the punitive measures that happens for those that break the law in as far as this is concerned was very punitive to the employers. So it needs to be a bit more balanced. So for me, I stand to reject. Thank you, Mr. Speaker.
The Honorable Zamzam Chimba.
Asante sana Mheshimiwa Spika. Na mimi niweze kusema kuwa japokuwa nia ya kuleta mswada huu ilikuwa nia nzuri, lakini tukiangalia kwa undani tunaona kuwa itawanyima wengine raha ya kufanya kazi kwa amani, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, mimi napinga marekebisho katika mswada ambao umeletwa leo kutoka katika bunge letu la Senate. Mheshimiwa Spika, wafanyakazi katika taifa hili wameangaliwa vizuri na wamewekewa kanuni na sheria na masharti na mambo yao katika katiba yetu. Ukiangalia katika kitengo cha ajira wameangaliwa vizuri sana, Mheshimiwa Spika, na hii nikiangalia itakuwa inalemea upande mmoja na wengine watakuwa pengine kama mwajiri atakuwa amelemewa sana, Mheshimiwa Spika. Katika serikali yetu sisi tunataka mfanyakazi akiwa na furaha na mwajiri naye pia awe ana furaha na kuangalia pia kazi yake, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, haya marekebisho yalioletwa, kwa mfano hapa juzi Mombasa nimekuwa sehemu nikiangalia sheria za wafanyakazi wa EPZ, Mheshimiwa Spika, lakini tukafikia maelewano kuwa lazima wale wafanyakazi haki zao za kimsingi ziangaliwe, na vile vile pia haki ya mwajiri naye pia aweze kuangaliwa ili waweze kupata balance, kwa sababu tunataka taifa ambalo linaweza kusonga mbele kwa mwafaka uliowekwa katika katiba, Mheshimiwa Spika. Kwa hiyo katika hili mimi nitamwambia kamati ya Leba katika Senate hili, kama mama kaunti wa Mombasa nimelipinga. Lazima sheria ni msumeno ukata mbele na nyuma, tukuangalia mwajiriwa, tuangalie na anayemwajiri, Mheshimiwa Spika. Lakini hata hivyo pia walete sheria na kanuni nzuri ambazo sisi tuweza kuzipitisha hapa, kuangalia haki za wafanyikazi zinafuatiliwa sana, Mheshimiwa Spika, kwa sababu kuna watu wameajiriwa, kwa mfano mtu anakaa katika contract mwezi mmoja na amekaa katika ajira miaka 10, Mheshimiwa Spika. Vitu kama hivyo tunataka kamati ya Leba waweze kutuletea, ili Wakenya wakiwa katika kazi, kwa mfano tumepata wengine wanafanya acting, mtu amekaa miaka 2.5, anaangaliwa vipi aweze kuajiriwa rasmi ili na yeye aweze kufurahia matunda, Mheshimiwa Spika. Watuletee sheria ambazo tutaangalia mwajiriwa katika kampuni pengine anaangaishwa na yule aliyoko juu yake, pengine anamsumbua kijinsia, pengine anamsumbua katika mambo ya ngono. Tumepata cases nyingi kule, Mheshimiwa Spika, na mimi pia hapa nataka nichukue fursa hii, Mheshimiwa Spika, kwa vile ni mama Mombasa, nishukuru ile kampuni ya EPZ ya Mombasa. Tulikuwa na matatizo, lakini tumekaa nao, tumejaribu vile tutakavyoweza, tumesuluhisha. Wafanyikazi wataangaliwa vizuri, na mimi ujumbe wangu pia kwa wafanyikazi wa EPZ Mombasa, na nyinyi angalieni kazi yenu, tusiweze kufunga makampuni yakienda Kenya yahitaji pia kujengwa na watu kama hawa. Mambo yenu yameangaliwa vizuri, na nyinyi muangalie zile target zenu, zile kazi zenu mlikuwa mmepewa kufanya, mufanye kwa uadilifu ili tuweze kuona makampuni yetu yakienda vizuri. Asante sana, Mheshimiwa Spika.
The Honorable Beatrice Kimei.
Thank you, Honorable Speaker, for giving me this opportunity to add my voice to the bill that we have. the employment, that is Amendment Bill 2022, the Senate Bill number 11 of 2022. Honorable Speaker, I want to believe that the owner of the bill had intentions, but to me, it is not a balanced bill. It is geared more towards the employer and no much interest with the employees. In this case, I reject the bill. For one, Honorable Speaker, the relationship between the employer and the employee is very important. Relationship here in terms of the output. So when we talk of the employer should not actually, or the working hours should not exceed what is there. That is to tell us that the employer has no say when the time is over. Yet sometimes here, the work that is there can go beyond the stipulated hours. And in this, it tells us that it will be very mechanical for the employee and the employer. I also want to say that it is not clear, even from this bill, when the bill talks of only in cases of emergencies, but which are these emergencies? It is not stated which is the emergency and which is not. And putting also into consideration, we have some employees who have to work beyond the working hours. For example, the teachers. What do we say about those working in boarding schools? Because they have to take care of the students all through. Does it mean when the time is over, they have to go home? Who stays with the students? Who takes care of them? Who check on their issues? So to me, this bill is not the right one, and therefore I reject, saying that they have to look at another way out. Now, I'm also asking myself, if the employee has an emergency and is at home or wherever, are they not supposed to engage the employer? That is my question. Because now, if it is only the working hours, it means even if they have an emergency too, they are not supposed to engage an employer. So this bill will not make life very easy for the employer and the employee at the same time. And therefore, in the strongest terms, I reject this bill. Thank you, Honorable Speaker.
The Honorable Lillian Sioi is in the House. Being absent, next we have the Honorable Wilberforce Oundo.
Thank you, Honorable Speaker. The Employment Amendment Bill, Senate Bill number 11 of 2022. Honorable Speaker, when I perused through this bill, it reminded me a similar bill that came from Senate in the last term, sponsored by the current governor of Murang'a County. And it left me wondering, Honorable Speaker, that under Article 96 and in totality on the chapter on legislation, Senate is bestowed with very heavy load to protect the interests of the county and ensure devolution works. And also reminded me that again in the Constitution, Senate participates in lawmaking and only participates fully in matters to do with revenue distribution between the two levels of government. I was perplexed, astonished, and I got apprehensive that how can a whole Senate waste valuable time to debate and pass. And Speaker, if I wasn't in Parliament, I would do what we used to do when we were at the lecture halls, what we would tell the students. But since this is Parliament, and there's some issue of parliamentary and the rest, let me just say from the onset that this bill is a bill that I reject in totality. it is something that ought not even to have been allowed to see the floor of parliament. Yesterday, Honorable Speaker, we just told here so many times, trying to look for ways and means to ensure that valuable parliamentary time is not expended to discuss this bill. Honorable Speaker, I reject on three strong grounds. Number one, the issue of labor relationship in this country are so big, are so demanding, that the issue of conducting an employee after the so-called working hours does not rank anywhere in the order of priority. To a teacher who is teaching in Mandera, whether the deputy, whether a student calls or not, is not a priority to the teacher. To the worker industrial area, is not a priority what time they can be conducted by the plant operator or the plant manager in an industry. To an unemployed person, this is not a priority in labor relationship. To an underpaid person who is hanging on the job that he has, this is not a priority. The priority is job security, priority is improved working condition, priority is better pay, priority is the ability to improve so that they can move to the next level. I would have wished an amendment to the Employment Act would have literally been directed towards that line. But directing us on mundane issues, hopelessly unproductive issues, is a terrible waste of national resources. Secondly, Honorable Speaker, I would have imagined, I'm told the sponsor of the bill is a young person, and like the old hogs like us who are here, is a young person. And I would thought the young person have weaned themselves from this retrogressive and outdated mentality that working hours are fixed working hours. We have seen the Kenya Kwanza government, even the Uhuru Kenyatta government, push towards digital economy. And we practiced during the corona time, where there are no fixed working hours. All that is required is delivery. All that is measurable is the output. Honorable Speaker, we operate consultancies. We operate other things. I never at any time request anybody whom I'm working with to be on his desk or his desk from 8 a.m. to 5 p.m. All that I'm looking for is delivery of service. All that I'm looking for is the output. Many Kenyans of the youthful age are working at home, and the output and the income far much exceeds those people who slug themselves from day to evening on a desk job. Honorable Speaker, we go all over our constituencies telling our young people that the white-collar jobs are no longer there. The jobs where you go to a desk, you are given a swinging chair, there is tea in a flask with the biscuits, with the flower vase, with a telephone extension on your desk, are long gone. We are telling them, create your own time, to work at your own free time, to make sure you put food on the table and meet your bills. With this amendment, if it ever became a law, we would go back 10 steps, more than the 2 steps you have made, to entrench back this mentality that I must work a certain time. Honorable Speaker, it simply means, if, for example, we are here in Parliament and we have those extended working hours where we live here at midnight or so, when you get home, when you are hungry, your house girl or your house help will not cook for you because it's beyond working hours. You will sleep yawning, and the morning you might not be able to deliver. Even when you go to bed, you might turn the bed the whole night and unable to sleep and do that pertains to sleeping. Honorable Speaker, it also means the members of parliament who are here, you will not call your fund accounts manager beyond 5, because he will tell you, sorry, it is beyond working hours. Cheregai Bill says I should not pick your call, or he will contemptuously disconnect and atadunga, contemptuously, and you will do nothing. It means, Honorable Speaker, you will not call your doctor when you suddenly fall sick, because you will say it is beyond working hours. It means when there is an emergency, MOH will not call a nurse who is off duty to come and render services because it's off working hours, regardless that those are essential services under Section 18 of the Employment Act. It is a necessary legislation. It's something that does not bother, should not even have found its way here. And these are some of the kind of the bills, Honorable Speaker. We should just kill them and go back to the Constitution and the standing order, so that we not even have any reference to any other places. With those very few remarks, I would have wanted to take all the time to lecture on the issue of labor productivity. Kenya is said to be comparatively low labor productivity, to have a low labor productivity. You bring this kind of a bill, then all the time tutakuwa tunapiga sherehe as from 5:15 until the second day we do not produce. So, Honorable Speaker, I want to urge, and I must thank the committee. They were courageous enough and said reject in totality. I oppose and say the members of the National Assembly, we have more pressing issues, we have more important issues to deal with this country. Let's reject totality, and I oppose this bill. Thank you, Honorable Speaker.
Very well. The Honorable Samuel Chepkonga, do you want to speak on this?
I thank you very much, Mr. Speaker. Mr. Speaker, I rise to support the recommendation that is contained in the committee's report that is dated the 6th of December 2023. Mr. Speaker, it is very unfortunate, as I heard Professor Oundo claim that this bill was sponsored in the Senate by a young person. In fact, the import of this bill has the unintended consequences of suppressing the rights of the youth. It is not even helping the youth in any way. Two, Mr. Speaker, I've gone through the report, and I'm surprised that this bill has continued from the Senate all the way to this House, when in fact the Public Service Commission rejected this bill. Two, court to itself, Central Organization of Trade Union, rejected this bill. That represents the workers. Three, the Federation of Kenya Employers also rejected this bill. So the question that you ask is, whose interest is this bill intended to serve? It has been rejected by the employers. It has been rejected by the employees. So whose interest is this bill intended to serve? It is not intended to serve any interest at all that will further the interest of the worker in the marketplace. In fact, this bill goes against or is in contravention of the International Labour Organization Convention. Now, it goes against the international best practice. So if a bill is in contravention of the ILO, in which Kenya itself is a treaty member, and if we are a treaty member, you know that the convention has been imported pursuant to Article 2 of the Constitution, which says that all conventions in which Kenya is a signatory are laws of this country. So if it is in contravention, if it's in conflict with the ILO treaty, so this should not even be wasting our time considering something, and I should not waste a lot of my breath speaking to something that is in contravention of the Constitution itself. Anything that is unconstitutional, Mr. Speaker, should not even be entertained in this House. We should not be wasting the precious time of these members of Parliament who should be resolving matters that are of concern to the people as required by the Constitution. So the only favor that we can do to this particular proposal is to reject it in totality. And we should not waste a lot of time, and I don't want to take too much time, Mr. Speaker, and therefore I support the report of the committee to reject this bill. I thank you, Mr. Speaker.
What's your point of order, Honorable Member?
My point of order was on the Honorable Odo, I think, the Daktari. He actually used unparliamentary language, but I actually wanted to contribute.
Order, member.
No, I wanted to contribute.
It was overtaken by events.
No, I wanted to contribute to this particular
It
bill.
was already overtaken by events.
So can I contribute?
No, you rose on a point of order.
I rose on a point of order, but I want to contribute.
Order. Take your seat. Let's have the Honorable Onyango Koyo.
Thank you very much, Honorable Speaker, for giving me the opportunity to talk to this bill. Although I'm a member of the committee that already spoke to this bill and rejected it, Honorable Speaker, I want to say that this bill is not going to add value to the working class or anybody who is serious in this country. Workers and employers have a CBA, something called collective bargaining agreement, in which they agree on working hours, working conditions, the salaries, and so on. And this bill is not going to cure or introduce anything a lot better. We rejected it because our communication system are still very faulty. Merciless employers would capitalize on this and send workers home anyhow, based on the fact that they have been tried to be reached or they have been invited through these gadgets and they were not able to be found. So several years after independence, we appeal that those who are serious bring to this House bills or issues that they have researched and found that they are coming to add value or they are new and they are going to drive the country forward. Senate should be very serious, and because there are so many pending issues of the county government that they need to deliberate on. And I therefore believe that, plead with my colleagues in the House of Parliament that this bill is a bill that does not add any value, and we should not argue about it so much. We should look at it and reject it in totality, just the way as a committee we looked at it and dismissed it. Thank you, Honorable Speaker.
Honorable Thukukwenya.
Thank you, Mr. Speaker, for this opportunity to contribute to this bill from the Senate. From the onset, I want to join the chorus, so to say, in rejecting this kind of a bill. In fact, Mr. Speaker, I want in a very special way to reprimand the Senate House Business Committee for allowing such a matter to even be given precedence by the same committee to be discussed in the Senate and for forwarding the same to the National Assembly. Mr. Speaker, these are some of the bills that make Parliament look like a joke. And I have taken time even to interrogate as to who the author and the initiator of this bill is. And from a judgment, I could tell from the word go that this is a person who is in this in Parliament, either having not ever worked anywhere in any of our reputable organizations, and the reason as to why, or rather had a bad day at work, had a serious disagreement with the former employers, and the reason as to why he came up with such a bill to limit the working hours of employers in this country. You realize so much has changed, and I'm actually particularly perturbed that the author of this bill is a young person who should be well versed with the dynamics of the world today, that our economy has really changed, and actually we do not have specific working hours. The world has become a village whereby when it is morning here, it is at night elsewhere. a case study. Before I joined Parliament, Mr. Speaker, I was a serious businessman. And my working hours and my staff used to work between 5 in the evening to morning, because that is when we'd be in touch with our clients or our suppliers. And Mr. Speaker, looking at this bill, because I don't want to say much, I want to dismiss this kind of thinking. Actually, the writing is not even worthy the paper that is typed on, and therefore I reject and call upon the Senate Business Committee to be more serious and to interrogate the kind of bills that they are passing. It is unconstitutional ab initio, just like it has been said by the Honorable Chepkonga, and therefore does not deserve to be in this House. We have more serious matters to discuss in this House. Thank you, Mr. Speaker, for the opportunity.
Yes, Honorable Ruku. Honorable Ruku. Are you contributing on this? Yes, and as you contribute on this, you must remember our standing orders, that it's not in order to reprimand the Senate for having brought this bill. Proceed.
Thank you, Mr. Speaker. Mr. Speaker, I rise to be contrary to what my colleagues have just said, and I respect that. I respect that. As far as this employment bill is concerned, Mr. Speaker, I rise to support the bill. I rise to support the amendment because of a number of reasons. One, it gives the employees ample time to have the personal space after working hours to enhance their social welfare, which is something which we have not been able to see. Sometimes it's neglected and it needs to be enhanced. Kenya is an economy which is growing at a very fast rate compared to other African nations. And the more we think for futuristic, the better for the employees of the Republic of Kenya. Two, Mr. Speaker, this bill protects employees from exploitation and disciplinary action if they fail to act on communications outside the agreed working hours. It is actually enhancing the freedoms and rights of employees, and they should not be taken advantage of. Number three, Mr. Speaker, the bill protects the employees' privacy from abuse and infringement by the employers. We have seen this happening again and again within our employment sector, and employees need to be protected from privacy. I mean, they need to enjoy their privacy from being abused by the employers. Number four, Mr. Speaker, this bill will enhance respect and dignity, and therefore it will enhance productivity, which in the long terms will create productivity in our economy, strengthen the economy, and it will ensure the seamless promotion of work and life balance, which is critical and important. I support this amendment. Yes, I support this amendment, Mr. Speaker, because of those four very critical reasons. Thank you, Mr. Speaker.
Maybe before we give the next person to speak on this, it will be very important to order members to refer you to our standing order number 87, that it shall be 87.4.5. It shall be out of order for a member to criticize or call to to question the proceedings in the Senate or the Speaker's ruling in the Senate, but any debate may be allowed on the structures and roles of the Senate in Parliament. So please be guided. Honorable Chair.
No, thank you so much, Mr. Speaker. Mr. Speaker, as the Honorable Ruku was contributing, I imagine the Honorable Ruku receiving a message today at 6 o'clock from his constituency manager about the death or the sickness of one of his staff in the constituency. And I wondered whether he was going to call that constituency manager back. Or, I mean, I just imagined at 10 p.m. today, the Honorable Ruku receiving information from one of his staff members that one of his campaigners is unwell or has an emergency. And I imagined whether he would call that person who has sent the message back, or he would wait until those working hours, assuming what to set them up. And so, Mr. Speaker, it's good to think about the ramifications of some of the provisions we make when we come to Parliament. Because, Mr. Speaker, I believe employment, working for, with, or under, assumes that over time, people get relationships, people get to like their jobs, people get to learn how they work. And Mr. Speaker, I don't imagine that employees or employers would be getting in touch with each other after hours, in quotes, for fun. And so much as people may have an issue with an employer calling back an employee or calling to make an inquiry or calling after hours, I believe that this is a knee-jerk reaction. I believe that this is tantamount to summoning a hammer to fight a mosquito. So, Speaker, I wish there was a way in which we could leave this to the good sense of the employers and the employees. Because the moment we say that there are times when an employer cannot or will not get in touch with an employer, what about emergency situation? What about at times when the employee himself or herself may have done something that needs to be corrected? What about circumstances where the activities of work require that they keep in touch throughout? And like the Honorable Wundo has said, in a world where nowadays people work without seeing each other, in a world where we are talking about Taptengle, where someone is working in Europe for someone in Africa, or someone is working in Africa for someone in Canada, why would you try to limit? Why do you want to limit these kind of interactions in cases where they actually may make the work to be easier or better? So, Mr. Speaker, I believe that this bill is ill-guided. I believe that it will not improve anything in the work environment. On the contrary, it may make the people who already are working lose their jobs. I imagine a situation where someone refuses to pick the calls of their bosses or of their supervisors, and the following morning they are given a letter saying, your job is over. Where will this member be? Mr. Speaker, I think this is some of the things that we should leave to the realm of policy and work environments as they evolve, instead of legislating on matters that we cannot even supervise or enforce. Mr. Speaker, I oppose. Thank you.
The Honorable Basil, followed by the Honorable Lady Lillian.
Thank you. Thank you, Speaker. I can see my brother, Honorable Wilberforce, is smiling. He knows what I'm about to say. I think I'll join my friend, Honorable Ruku, to fully support this bill. And the reason why I support it, there's a reason why we have working hours. If we talk of 8 hours working hours, that has to be respected. We have seen a situation whereby employers abuse workers. So we need to protect employees. And that's why I fully support this bill. Number two, it's important to understand that work-life balance is very important. We have seen employees committing suicide because of stress. This is imposed by employers who do not respect the working hours and the work-life balance. So it's important we understand this and not just oppose for the sake of opposing. Number two, we need to understand also, because I've been hearing many people saying this is a bill proposed by a young person. They need to understand young people also have responsibilities beyond the formal employment. Some are engaged in productivity, making, contributing to the home, welfare in their homes, and we should not take advantage of that. There are some people who are saying the life is changing. Yeah, we are in a changing lifestyle, but it's important to understand, as much as we are in exponential age, which is technological age, workers need to be respected and allowed to work within the specified working hours. Anything beyond that should be subjected to compensation that has to be agreed between an employee and an employer. Number 3, it's important to also understand that we should not take advantage of unemployment. We know, of course, like in Kenya and the rest of the world, the demand for work or the supply for work is limited compared to the people who want work. So employers taking advantage of unemployment in countries like Kenya and other countries is unacceptable, and we must protect the dignity, the respect, and ensure employees work in an environment which is not toxic and which understands that they are there to work within a specified period of time. So with those few remarks, I fully support this bill, and I request my colleagues to understand that the bill was brought based on reasons that have been observed in line with the current working environment. Thank you, and I support the bill.
Madam Lilian Sioi.
Thank you, Mr. Speaker, for giving me this chance to stand up and oppose the bill. I happen to be a member of a Labour Committee. I sit in that committee, and as we were going through it, Mr. Speaker, I felt like we have a number of loopholes. I stand to oppose this bill. One, I feel it is going to promote laziness amongst the employees, Mr. Speaker. The reason as to why I'm saying this is because when I'm working and I know by 5 I'm supposed to leave, whether I have completed what I was supposed to do or I have not completed, my employer will not call me to ask about any other business apart from the following day in the morning at 8 when I resume duty. So, Mr. Speaker, I feel like this bill is going to make our employees lazy. Secondly, Mr. Speaker, this bill is going to make our employees rude, and it is going to make employers lose the powers of being an employer. Because I'm trying to imagine calling an employee, probably maybe there is something you want to ask, Mr. Speaker, and the employee disconnects the call because it is past the working hours, Mr. Speaker. I feel that will be very rude of the employee to the employer, and it might even cause more losing of jobs, because I don't think employers will stand that, Mr. Speaker. Thirdly, I feel this bill is going to affect our economy. Our economy is going to drop. I say that because when I'm supposed to work and finish my duties by 7 and I don't, or maybe by 5 and I don't, then I go home without completing, then the following day is when I'm coming to continue with what I was supposed to do. That is laxity of work. I want to give a good example of a driver. Probably maybe the driver was supposed to take some goods to a certain place. Then in between, probably maybe there's some accident or something happens in between, and you are not able to reach to your destiny, and time has elapsed. Then that driver stops at there and say that my time is up, and therefore I have to be paid because I have not reached to my destination, and I need to get a place to put up and probably maybe even feed. So, Mr. Speaker, I don't agree with this bill. I feel like there are some amendments that we need to amend on this bill before we pass it. But passing it as it is, we will be jeopardizing the powers of our employers. Thank you so much.
The Honorable Gitonga Murugara.
Mr. Speaker, I contributed on this one, so I can't speak a second time. I'm anxiously waiting for the next one, which is equally bad.
Oh, you already booked again?
Yes.
You wait until the next business comes. From the look of things, I don't think there's anybody who okay, move it. What's the honorable members? Well, and who are you? Oh yeah, okay, Kiguma MP. Proceed, please.
Thank you, Honorable Speaker. I think I start first to oppose the bill as it has been brought, and I support the Labour Committee for rejecting the bill in totality. However, I also want to point out that, like some of my colleagues have observed, there are some very pertinent issues that need to be looked at seriously regarding the work-life balance that we keep talking about to our employees. There are employers who abuse that trust, and some people are working 24 hours a day, because once you go home, they start sending you messages through WhatsApp, they send you emails, you have a laptop that you take home, and I think it's totally and entirely unfair that we put some of our employees through some very unfair labor practices. So as much as I oppose this, I think from where it came from a good intention. I would not put any ill will on the person who moved the bill. However, based on our circumstances and where we are, I would think of an area I come from. I come from Kiguma, and we are tea growers and coffee growers. And like someone has asked, if you have a driver who is taking tea leaves to the factory and his shift is over, does he stop the vehicle, stop speaking calls, disconnects? What do we do under those circumstances? Some issues are not critical. You cannot say that he's a doctor, so he's supposed to be working 24 hours. What do we do about our young people who are working in business process outsourcing? Those are areas who are covering the whole world, and they work for companies that work odd hours, depending on where they come from. When I see that the Honorable Senator is proposing that we form a committee for any company that has more than 10 employees, so that they discuss when you can pick calls and when you can disconnect calls, I think it's a nuisance element there, in the sense that you cannot have companies who employ thousands of employees, and I'm giving an example like Safaricom, having them to come and decide and agree on how we will be communicating via SMS, via calls, what time to pick, when to disconnect, and when you are allowed maybe to even abuse your employer. I think we should reject. What we should encourage, as much as we are a lawmaking house, both Senate and the National Assembly, some bills ought to go through some critical analysis by the House Business Committees, so that if a bill is found to be wanting or lacking in some element, we are able to advise the person moving the bill that maybe it can be improved in this nature, maybe it can be helped in certain ways, so that also we don't do work that we give a lot of work to our committees to look at some bills, and maybe they would otherwise be looking at other important bills and issues that would affect employees. So I stand to reject in totality and entirety of the bill and support the Labour Committee for doing the same. I thank you, Honorable Speaker.
Ms. Kemei, did you contribute on this bill? Okay. Under the circumstances, it looks like there's no more member of parliament member who wants to contribute on this bill. Can the mover be called upon to reply?
Okay, thank you, Mr. Speaker. Mine first of all is to thank all the members of this House who has contributed on the report, and I think they have enriched the bill in a wider way. And Mr. Speaker, we have gotten a lot of information that were overlooked, whereby you can't move the issue of employment from a civil case to a criminal case, because that's one of the areas that they have done a lot of effects, whereby the issue of employment, if there is issue between the employer and the employee, is about a civil case, whereby members have clarified and said they go by damages, but you cannot take them to criminal case, Mr. Speaker. I want to say, Mr. Speaker, that the issue of the person who registered the bill could be right, but Mr. Speaker, most of the issues that he has raised, Mr. Speaker, are covered in the employment law, the issue of compensation, the issue of overtime, and therefore, Mr. Speaker, we don't have to legislate on switching on and switching off the phone. I think he should develop a policy that can be able to guide on those issues without necessarily going back to registration. Mr. Speaker, the members has put currently the government, mostly or the workers are not working on hours. They are working on output, whereby we don't consider too much on the hours the person is working, but mostly on the output. And also, Mr. Speaker, it has been confirmed is that most of the institutions that deal with workers have rejected the bill. The Public Service Commission has rejected it. COTU, which starts and works for the workers, has rejected it. The employers' organization has rejected it. Therefore, Mr. Speaker, as I say, this bill, Mr. Speaker, as the committee have said, and most members has confirmed, it needs to be rejected. And those members who feel that the bill is necessary should look for a way that it can be legislated on a policy way, but we can't legislate a law in this nature. Mr. Speaker, I respond. Thank you, Mr. Speaker. I beg to reply, Mr. Speaker.
Honorable members, I defer the putting of the question on this bill another date. In the meantime, I'll go back to the order. This has been ordered again, so we have order number 10. Sorry, number 9, which is the Natural Resources Benefit Sharing Bill, Senate Bill number 6 of 2022. Yes,
Order number 9, the Natural Resources Benefit Sharing Bill, Senate Bill number 6 of 2022, second reading.
Proceed, Honorable Kemei.
Honorable Chair, Honorable Speaker, I stand on behalf of the Chair and members who wish that this bill be deferred to a later date. Thank you, Honorable Speaker.
Fair enough. Granted. This bill is also ordered now. It's order number 9. It's also deferred to a later date. We now go to order number 10, which is the original order number 9, the National Disaster Risk Management. What's your point of order, Honorable Oundo?
Honorable Speaker, I think for neatness and for record purposes, Parliament is a house of records. The author or the mover of the bill is Kimani Chungwa, leader of the majority party. So unless my honorable colleague is seeking deferment on behalf...
She did not move.
Or if she's seeking deferment on behalf of the mover.
That's a communication.
Yeah, so we need for neatness purposes.
Fair enough. Next order.
Order number 10, the National Disaster Risk Management Bill, National Assembly Bill number 24 of 2023, second reading.
Where is the leader of the majority to move this one? Do we have any communication from the... Yes, Honorable Murugara, the chair of the JLAC.
May we kindly also step that one down?
Yeah.
Because the leader of majority is not here to move it.
Okay.
We have other business ahead, which I think
So
we are ready to
your
transact.
request is we defer it to another
Request
date.
that we defer to a later
Okay,
date.
granted. I've deferred this one again. Next order.
Order number 11, the petitions to Parliament Procedure Amendment Bill, National Assembly Bill number 51 of 2022, second reading.
Yes, the Honorable Chieng.
Thank you so much, Mr. Speaker. Mr. Speaker, I beg to move that the petitions to Parliament Procedure Amendment Bill, National Assembly Bill number 51 of 2022, be now read a second time. Mr. Speaker, the public petitions is one of the very new and novel ways in which our new constitution made it mandatory to ensure that Kenyans are able to participate in parliamentary proceedings. They are able to ensure that their matters count the floor of Parliament, Mr. Speaker. Mr. Speaker, just like anybody can petition the High Court of Kenya today, any Kenyan can also petition Parliament in whatever manner and whatever form. Mr. Speaker, so this process of petition in Parliament has been going on since the new constitution came to be. And so the reason this bill was proposed was to just streamline that process, to streamline the way Kenyans engage with Parliament in terms of petitions, to make it easier for Kenyans to petition Parliament, to make it easier for Parliament to communicate with the rest of the world in as far as the petition is concerned, Mr. Speaker, and to ensure that petitions don't take so much time once they are brought to Parliament. Mr. Speaker, today, under our new constitution, anybody can petition the High Court or Supreme Court just by a letter. You do a letter, handwritten, then it have to be printed. You send it there, and they're duty bound to act on it. Yet in Parliament today, the way we've worked around receiving petitions, the way we've got around processing those petitions, makes it difficult for Kenyans to engage with the Parliament. And so this amendment, Mr. Speaker, is meant to ensure that the petitioners can approach this Parliament without undue regard to form and formalities, without due regard to so many things that they must provide to us. And that's why, Mr. Speaker, these amendments talk about having a standard form that a petitioner just goes to the website, fills it in, and brings back. Mr. Speaker, we are removing, Mr. Speaker, the requirement that the petitioner must provide so much evidence about what is petition Parliament about. The only thing we are saying now that this new bill is that a petitioner just needs to tell us, is this matter pending in any court of law? If it's pending in court of law, don't bring to us the proceedings in that court. Just tell us the case number, and that will be sufficient. For now, we ask you to bring, the pleadings therein, the judgment therein. Now, what Parliament will require under this new amendment is just tell us what case number, in what court. Is it commercial division? Is it a criminal division? In which part of the country? And that will suffice, Mr. Speaker. Number three, Mr. Speaker, there are people who have been saying that, we should not, the clerk should not be the one communicating the petitioners. That the petitioners should be communicated to by the petitions committee, Mr. Speaker. Mr. Speaker, you can imagine if someone petitions Parliament today about flies, and maybe the petition is not done in the form required, or is not done in the manner that Parliament should look at it, why would a petition go to the committee for the committee to look at whether the petition is eligible or not? We as a committee of procedure and those rules of this House think that the clerk of the assembly should have some residual powers to summarily deal or communicate with the petitioners on matters where the petition does not meet form, where the petition does not, for example, disclose who is the petitioner. Why would the clerk take that kind of petition to the committee? If it's very clear to the clerk that this is a matter that is ongoing in court and what is being given to Parliament is not sufficient, why do you go to the committee? So we're still retaining the role of the clerk, because initially someone is proposing that the committee is the one that should communicate to the petitioner. Mr. Speaker, all the communication that comes from Parliament, even the committee ones, to the judiciary, to the presidency, because if they pass through and they are done under the hand of the clerk, not under the hand of the committee. And so we are retaining the residual powers of the clerk to communicate whatever decision that we make as a house or as a committee to the petitioner, Mr. Speaker. Mr. Speaker, the matters upon which anybody will petition Parliament are diverse. They are not one or two. They are as wide as the world is. And so what we are saying is that once a petition is processed and allowed to go through, then it now goes to the committee, and the committee alone cannot make the final decision on a matter under petition. So we are saying that once the committee sits and deliberates on a petition, the report of that committee will be brought back to this house, so that the matter of a petition cannot end at the committee. The committee says that, oh, we looked at this matter, and therefore we think this is the position that we take, and the matter ends there. Whether the committee of petitions approves or investigates, it must be brought back to this house, whether the house decides on the petition one way or the other. Speaker, the whole